before court. You can't now bring in further submissions from the side. The state had time to make this decision or elect to go by way of affidavit. They had time to consider the reasons they wish to prefer to this court, and that they've done. So the state must please desist from making submissions to this honourable court that does not fall within the realm of what is contained in their affidavit. The case law in this regard, I submit, Your Worship, is plain and it's strike law. Your Worship, I then wish to briefly to hand up the following to the Honourable Court. Your Worship would recall on the last occasion we made an offer to the state and to the investigating team to approach us, and we will provide them with whatever evidence is necessary to enable them to deal with the issues that they raised in their affidavit. I beg to hand up to the Honourable Court, and one for my learned friend. I know she's in possession of it, but just for the record, a complete trail of emails between my attorney, Mr. Matopo, and Colonel Maritz of the Hawks in this, and I'm not going to go through it for time reasons, Your Worship. What we've done, and I will basically summarize it. So on Wednesday evening, Wednesday afternoon, 5:15, after the court adjourned, we provided them, we dealt with the issue of the Bushiri's minor children. There seems to be some suggestion, we heard some whispers that that's a suggestion that we must let the court pertaining to the minor children, Your Worship, and we made it patently clear that Colonel Maritz has always been involved with the issue of the minor children. He knows that the children are in Malawi, and the children travels up and down to South Africa since the applicants' their passport has been detained with him. He's been intimately involved with Mr. Nkwashu in dealing with that. It is patently clear, Your Worship, that when the children are with them, which they still were at the time of the arrest, and they are still in South Africa, that they are a family unit, that they live together as a family. Your Worship, we have canvassed this issue more fully in the ultimate bail affidavit that we will hand up to the Honourable Court. The next issue, Your Worship, will see on page 1, we deal with the address of Ms. Ntlokwani. We have already, in the affidavits that we handed up specifically for purposes of dealing with the issues raised in the state's affidavit, dealt with the following. We said there what the specific addresses is, because the investigating team said they were not sure of the addresses as they were contained in the affidavit, so we spelled it out for the chapter and verse. That is dealt with in paragraph 2 on the first page, Your Worship. We also went one step further. In paragraph 4, we referred them to the previous address where the applicant lived. The bank accounts that's under preservation, they said they will provide full details. Your Worship, I need to apologize to the court. I made an error when I said bank accounts. I was meant to say that one of the assets, that's the aeroplane, that is under preservation. And in that regard, what we've also done is we forwarded the actual preservation order to the police in this matter.
So let me get you straight, Councillor. The only asset that is under preservation is the private jet?
Is the private jet, Your Worship. The bank accounts are not under preservation. Your Worship, I think I made the submission because, as Your Worship is well aware, normally when you do a preservation application, it's linked to preserving all the personal assets, bank accounts, etc. And I apologize to the court for stating that we clarified that immediately with the police. Your Worship, then we also list in paragraph 4 all the family members by name and surname. Your Worship, we then, and I'm not going to now go through everything, we then went further. We provided the investigating officer, Colonel Maritz, with the title deeds of Ms. Ntlokwani's properties, the one in Port Elizabeth, as well as the one in Cape Town, and it's evident from it that she is joint owner of the said properties, Your Worship. That is, of course, a very simple fact that can be established by the police by doing a simple deed search. Your Worship, under 8 October, we provided them with the list of email exchanges between Mr. Victor Nkwashu, who's the applicant's attorney in another matter, and all of these deals with the flight arrangements, just again to prove to your worship that the police all along knew what the position is with the children. We know it, and there can be no suggestion or inferment that we try to mislead the court by suggesting that they stay here permanently. Your worship, the next set of emails is the one where we actually deal with the deeds of London and Tlokwani, and we attach the preservation order. Your worship will find the preservation order is indeed, it forms part of the documents that we attach, and that preservation order deals with all the relevant issues that's necessary in it. And then the very last one, your worship, on Wednesday, deals with, is an acknowledgement by Colonel Maritz of the various documents that we sent. Your worship, then we go over to yesterday. Yesterday what we did was your worship would recall that in this affidavit there's also mention made of the immediate family of the applicant 1 and applicant 2. What we did yesterday, we actually spoke to the immediate family. We took photographs of their passports as well as their visas and or the status that they have in this country, and we forwarded same to the investigating officer. Those documents are not going to hand up, your worship, for reasons of privacy. Safe to state, as an officer of the court, I informed the court that those documents were handed up. If your worship is so inclined to see it, we are prepared to make it available to the Honourable Court, but we ask that the content thereof not be distributed and be published by whoever has it. And we request very humbly that the state does the same. Your worship, just be with me. Now, your worship, then I'm going to very, very briefly deal with the issues of the law. There's many submissions I can make to your worship. I have, for your worship's benefit, and I know your worship knows the case, made a copy of State versus Mjali. It's a very well-known case, and I've got no doubt that my learned friend is au fait with the case. Your worship, what the important issues, and this, the learned Judge Moglageng went into great detail with the issue of arrest, applications for postponements of bail applications, etc. The most important issues we find in paragraph 24 of his judgment, where it deals with the fact that when the state requests a postponement, they seek an indulgence of the court. This paragraph specifically then deals with the constitutional rights of such an applicant, of the accused, i.e. in this particular case, the applicant. Your worship, if you then turn to the next page, the remainder of the paragraphs are also very important. Paragraph 27 deals with the evaluation of the court of the sufficiency of. I addressed your worship on the lack of
We apologize for that break in transmission there. We were bringing you live visuals of what's happening in court. Sheperd Bushiri and his wife Mary applying for bail. The representative quite passionate, saying that the state is arguing outside of the affidavit that they submitted to the court, which she says they are not allowed to do in terms of the application. She also spoke about how there are flaws with the state's case, saying one of those flaws is saying that Bushiri's home has a for sale sign outside of it, which perhaps indicates that he may be a flight risk. She says they went there to confirm those details and didn't see any for sale signs. If the state was being honest, her implication is they'd have taken a picture and she made a jibe. But how we live in a modern era and a cell phone picture would have sufficed. Off that, we also heard that Sheperd Bushiri's private jet is under preservation, but his bank accounts are not. Of course, this is when assets are seized and placed aside. So Bushiri has access to his bank accounts, but not his private jets. Of course, we heard a statement from him earlier on saying that he doesn't know what he's accused of. This fraud case of over 102 million rand, he doesn't understand, as he's a religious man. He's not a businessman, and we've seen scores of supporters. Our reporter outside of court, Sipho Steeman, saying that it could even be thousands coming out very passionately to defend Sheperd Bushiri, saying there's an agenda against them, even a threat that people may not vote in the local government elections if Sheperd Bushiri is not granted bail and released. Of course, we've got Sipho Steeman outside monitoring the proceedings and those supporters and seeing what's happening. And inside court, Mulema Waune is keeping us updated about what's happening. We are getting that feed and we're trying to restore it. What we are going to do is bring you a little bit of news about the coronavirus cases in South Africa and then try and go back to that. So the number of new coronavirus cases has
reference as he there with justice system in South Africa is not and at this I will of this on it's a that you worship and it's a problem that very specifically I think it was the majority judgment deals with the issue that it's incumbent on the state, and Carmichael's case said the same. The state needs to act independently and exercise a discretion when it places facts before the court. They need to play open cards with the court. Place all relevant facts before the court. They're not there to slavishly follow the suggestions of the investigating officer about bail, be granting bail, not granting bail, or postponing any matter. Your Worship, so with
we apologize once again for that break in transmission. We'll try and make sure that the feed that we're getting is stable and bring that to you. It's time for a short break. I'll be back with you soon.
I haven't had an opportunity to go through it and verify the contents thereof, but for this moment I have done.
But our provision ID accepted, pending your confirmation. Right, it is marked Exhibit H.
Whilst we're busy with that document, I saw the opportunity to look at it and wish to just place on record the following. The information pertained in the email, the first page of this panel of emails, marked Provisioners Exhibit H, is an email received or sent by Mr. Matoko, the instructing attorney, to Colonel Maritz. Please take note that it is dated the 21st of October 2020, 17:31 p.m. This pertains to information on the third applicant's properties. The state did make haste, Your Worship, and did everything in their power to follow this up. As we are speaking, the state is waiting for affidavits from police officials in Port Elizabeth as well as Cape Town. I had earlier this morning confirmation that a police official was able on both sides to attend, but I don't have
Have you got the affidavits with you? What do they say?
The rest of the correspondence, Your Worship, attached here too, one looks at the dates it was sent. The one dated the 8th of October 2020 pertains to the passport return flights of the children. I do not understand at this point why it is an issue. The state is aware of the fact that the children are currently visiting in South Africa, and the word here of importance is visiting. But the state will address this aspect during the formal bail application. Furthermore, Your Worship, the emails pertaining to information on, you see it's dated the 21st of October 2020. That is once again the property of Landin Plokwana and the preservation order that have already addressed. The state had made effort in following up. The state is also aware of the fact that the only property under preservation of applicants 1 and 2 is the aeroplane. What is of interest, Your Worship, is the list, the last email dated the 22nd of October, that is yesterday. And there's a read receipt at 2 o'clock pertaining to the list of family members. Your Worship, this in actual fact is corroboration and confirmation of the reason the state seeks an opportunity to follow up information that is relevant and necessary for this court to make a finding. What was, however, not mentioned, Your Worship, after the court adjourned, I was party to this discussion, so I don't want to testify in my own case, but Mr. Matopo was informed of the state's request to supply a proper list of all family members. I don't have access to the email of Colonel Maritz and what it pertains, so I cannot argue at this point whether that list is comprehensive and whether it complies to my request to Mr. Matopo. The questions about the property of the third applicant is definitely an aspect that the state wishes to address the court on in and during the formal bail application, as there are several properties listed to be her joint fixed properties. That cannot be done and could not have been finalized as we are speaking. With the court's permission, Your Worship, I'm just turning to, I will address the case law as also referred to by counsel. Sorry, Your Worship, there's a microphone here that's hindering me in getting to my documents. Here. I don't know whether it is hampering any recordings, but as it is. Your Worship, the state placed, I'm going to address the court as requested on our adjournment on Wednesday. The state placed before court an application of postponement in terms of section 50 oh, just one thing, Your Worship, sorry. There's an averment that the Exhibit A is misguided on the relevant subsections in the Criminal Procedure Act pertaining to this bail application. The court must take cognizance of the fact that the witness, the author of that affidavit, is a police official, and the misquotation of a subsection should not deter the court in coming to a correct and a just decision. Paragraph 7, the reference to section 60, subsection 11, should not be regarded as detrimental in the state's application for postponement. I'm sure the witness meant to refer to subsection 4 that is normally used in deciding on whether bail should be granted or not. Furthermore, Your Worship, I wish to address the court on what was placed before this court, an application for postponement in terms of section 50, subsection 6D of the Criminal Procedure Act. It was previously argued by myself that the request of a postponement is based on the fact that, one, the state will not be or was not on the first day in a position to adduce sufficient evidence and or information before this Honourable Court to reach a decision. And secondly, that it is indeed necessary in the interest of justice to do so. According to the Minister of Law and Order versus Hurley and another, that's a 1986 decision. The reference there is 1986, 3 SA 568 AD at page 579 E to I. For such a postponement to be lawful, it must be based on reasonable grounds. The court was presented with, firstly, reasons why the state was not on the first day of appearance ready to present evidence, and secondly, what the nature of the information is set out in the subparagraphs of that affidavit that the investigating officer needed to obtain by supplying a sworn affidavit, Exhibit A, and taken up as such. Thirdly, although Exhibit B confirmed that an interdict was obtained against the Department of Home Affairs and postponed the inquiry or the questioning in terms of Section 48 of the Immigration Act against applicants to withdraw their permanent resident status, it was argued or placed on record by the applicant's counsel that their status is unchanged. It is, however, my submission, Your Worship, if one looks at that exhibit, it is an order against the procedure envisaged in Section 48. And if I can refer the court to paragraph 31 of that judgment, paragraph 31. In my view, what was sought and granted in outer case supra differs from which is sought here. In the present matter, before court, the Department of Home Affairs is not prevented from exercising a statutory function. There is no interdict sought against the DHA proceedings in toto to justify a postponement. In opposing this application, the applicants produced 3 lengthy affidavits. The content of these affidavits are exactly the reason for this application. The mere production of a set of statements by the applicant does not place facts before this court. It should be verified, and the court should be placed in a position to see both sides of the coin. The state must have a reasonable opportunity to confirm the allegations pertaining to specifically the residential addresses, the fixed and movable assets, and also the family and occupational circumstances that will secure reasons why it's likely for the applicants not to evade their trial. In the absence thereof, the court should find against an application to grant them bail. And that would specifically refer to information that the court should satisfy itself in the question set out in Section 60, subsection 4A to E. It is the state's submission, Your Worship, that this application is in line and satisfies the dictum as set out and referred to by defence or the applications counsel in the Majali case. defense referred the court to specific paragraphs, but it is the state's submission if the dictum there is read in context, and if one looks at the wording thereof, this matter indeed falls in within the perimeters of the said judgment. Bishop, although it is an indulgence, and the state was from start, the state requested the court's indulgence, the state knows it's not a right for a postponement. State has also previously submitted that this is not a frivolous request or a request in frustrating the rights of the accused. If one looks at the wording used in the Majali case, referred to in paragraph 24, the state seeks an indulgence, consequently it must furnish cognate, sustainable, persuasive reasons justifying the granting of such a postponement. The word cognate also means convincing, sustainable means able to uphold or defend. And it is the state's submission, Your Worship, that the reasons placed before this court for the state's request of a postponement falls within that parameter. It is therefore the state's submission that it is necessary and in the interest of justice to find in favour of the state's application for a postponement in terms of section 50, subsection 6D, and if one looks at the wording of the state's application the whole time, that will fall within subsection 1 and subsection 5. That is my submission, Your Worship.
Your Worship.
Before you rest, I have a question for you. When it comes to the formal verification itself, and with the information that you have, what schedule is this in respect of each of the applicants before court?
All Schedule 5, Your Worship. Thank you, sir.
Your Worship, with the court's leave, there's just one or two issues that I wish to raise. I'm a bit confused at this stage, Your Worship. The submissions my learned friend made to the court all deals with issues that they intend to deal with in the bail application. Now, you can't deal with those issues at this point in time, Your Worship. Once we presented our application, and Your Worship rightly asked the question about Schedule 5, we bear the onus to start, we bear the onus to present our case. Once that is done, the state can then deal with many of these issues that were raised at this stage. They sought an indulgence, in my understanding of Section 50, in the interest of justice to tie up some loose ends. The loose ends that they referred to, we gave it all to them. This is not the bail application. May it please the court, Your Worship.
Right. The accused before court were arrested on the 20th of October 2020. That is all 3 of them. They've been in custody today. It is the 23rd of October. It's a Friday, which gives us a weekend in between. I'm told by the state that this is a Schedule 5 formal bail application. And considering that it is a Schedule 5 formal bail application, it is the applicants who bear honors, it is them who are supposed to start. I don't see the reason why they should be barred from starting their formal bail application. The state still has the benefit of the 2 days during the weekend to can do whatever that they need to obtain. They had yesterday, they have today, they have tomorrow, they have Sunday, and depending until when the matter is going to be postponed, they will still have time to can obtain all of that information. Meanwhile, the accused persons were arrested through warrants, meaning that during that period there has been an investigation that was conducted. I don't see why such information was not obtained. But be that as it may, it is fair for all parties that the state will have a chance to obtain that information in the meantime, and they cannot bar the defense from proceeding with their formal bail application, more especially because it is up to them to start. So why not please start your formal bail application?
May it please the court, Your Worship, we indebted for the ruling by the court. Your Worship, we have therefore prepared formal bail applications. Your Worship would recall the other ones we said we hastily got that signed only for purpose of the personal circumstances. Your Worship, I beg leave to hand up the affidavit prepared on behalf of the first applicant, Mr. Bushiri, to the Honourable Court. I provide my learned friend with a copy. These are all certified copies. Your Worship, may I ask in the interest of time that we, and Your Worship can make such a ruling, that we don't read the content of the affidavits into the record, and that Your Worship accept same as read. Your Worship will note the only changes to the to this affidavit relates specifically to the issue of the children. We thought it's in the interest of justice to amplify that aspect and place the Honourable Court in a position to understand that issue more fully. As I said, there seems to be a suggestion that in the way we formulated it earlier, that we tried to mislead the court. We deal with it fully here. So may I ask the court's leave that we purely hand this up and that the court accepts same as being read. So the Honourable Court, Your Worship wants me to read it in. I'm going to go as fast as I can. I'm going to do that, Your Worship. Affidavit by the accused for bail as envisaged by Section 60 sub 11B of the Criminal Procedure Act. I, the undersigned Sheperd Bushiri, do hereby make oath and state I'm an adult male and accused in the matter. I reside at 972 Victoria Avenue, Waterfall Country Estate, Midrand, where I've been residing since 1 December 2015. My wife, accused 2, and I are tenants in the aforementioned property. 2, I've been informed that I will be formally charged with the alleged transgression of the procedure of FOCA, seemingly money laundering, fraud and theft. I have, however, not had the benefit being informed what exactly the allegations against me is. The necessary details one expect to be confronted by the South African police when they effect an arrest. I've been informed that I will be provided with a charge sheet. At court, I therefore reserve the right to amplify this affidavit. We know that we've been provided with a charge sheet. 5, I verily believe the state has no case against me. I'm not actively involved in the business, and I do not know whether the fact that I'm a director in some entities caused my arrest. This would be unfortunate. I'm advised that the state must have evidence that I participated in the alleged offence, and then Section 3325 of the Criminal Procedure Act places an onus on the director to prove non-involvement in a criminal conduct by an entity if that was found to be unconstitutional. I thus challenge the state to show when I participated in the crime. 6, I deny any offence was ever committed by me. 7, it's for the specific reason I request information from the state as envisaged in 60.11.5 of the CPA to try and understand what the allegations by the state is in regard to the alleged bail transgression for the purposes of the bail application. 8, I accept that sheet of 5 applies to my bail application with regard as is had to the financial values mentioned to me during my arrest. I'm advised that in terms of the provisions of Section 60 sub 11B of the CPA, I must clarify my release. 9, personal circumstances. I'm 37 years old. I'm married and 2 minor children were born of the marriage. The first on 25 December 2012 and the second on 28 September 2015. My wife and I are living with both our children in a normally family setting. My wife and I are living with both our children in a normal family setting at this point in time. Whether we are with our children, whenever we are with our children, we are a family unit. Our children attend school and preschool in Malawi. The fact is well known to Colonel Maritz. The children, in fact, arrived in South Africa on 11 October and they are still here. In fact, they were with my wife when she was arrested at our family home. Colonel Maritz, together with Mr. Victor Nkwasho, our other attorney, are the persons that assist in making arrangements for the children's entry and exit into South Africa. Since our passports were handed to Colonel Maritz, our children have been to South Africa on a number of occasions. On each of these occasions, Colonel Maritz assisted with the travel arrangements. 9.3. As can be seen, my children are very young and at school to deprive them of the company of their father in circumstances where I do not understand the charges against me. I fail to appreciate why I could be a flight risk. I have no reason to run away. I have no reason to evade the trial, as I know I have not committed any offence, let alone an offence for which I should be imprisoned. Sub 4, some immediate family members are resident in South Africa, and we are a very close-knit family. 5, although my wife and I are Malawian citizens, I have permanent residence in South Africa, and I'm the holder of South African identity document which is in possession of the investigating officer. 9.6, I have 3 Malawian passports for the reasons explained there. Under the first passport is full, but it has a USA visa there, and it's valid for 10 years. The second passport also full as a Dubai and Indian visa. The third passport is also full and it has a United Kingdom visa in it. The fourth passport is a Malawian diplomatic passport, which I've also been using during some of my travels as I travel extensively. Need to keep all my passports with the visa. All my passports are in possession of the investigating officer. 9.7. My immediate family members are residents of and we are a closer family. Your Worship, I'm going to request the Honourable Court that this paragraph be deleted. We've dealt with this before. I'm going to strike it out and ask the applicant just to initial next to it. So 9.7 we are removing. Initial point, I'm going to uplift the court's original one later on. 9.8, I'm a very religious person and live my life according to the strict principles of my religion. I am the pastor of the Enlightened Christian Gathering Church with a following in South Africa of about 2.1 million members of congregants. The congregants in Pretoria alone is in excess of 100,000 active members. I have the following business interested in South Africa. Prophet Bushiri Sheperd Ministries MPC with the registration number 2014-1648408. Sheperd Bushiri Investment, registration number 2015-3860409/07. PSB Mobile, registration number 2018-08607307. SP Trading Platform with registration number 2017-0325-1908. Enlightened Christian Gathering Church NPC with registration number 2012-123598/08. Sub-6 Enlightened Church Gathering International Church with NPC with registration number 2019-0225-8/08. 997 The Great 12 Pretoria Limited with registration number 2017-5126-9907. Prophetic Channel with registration number 2014-1910507. The following business interests outside of South Africa: Bushiri Consultancy Firm in Dubai and in the United Arab Emirates. Have not vested any funds in the said Bushiri Consultancy Firm. 10.2 SBI Airlines, SBI Technologies, SBI Consultancy and also SBI Media. All these companies are shelf companies. SBI Technology known as Bushiri Bus, but it has since closed down. It was not profitable. There's also SBI International UK and SBI Pretoria Limited in Malawi, which also remain as shelf companies. Assets and income. My monthly income is presently 566,000 Rand per month. I have 20 employees in my personal employee, which comprise personal assistance, security, etc. My immovable and movable assets are listed in Annexure A. 10.5, 15 active bank accounts for different entities and for my own personal account with different banks. I've attached this list mark B. The alleged offence, I insist I do not commit the alleged offence. I'm advised that I will be afforded the opportunity to do the appropriate time, deal with the allegations levelled against me, and particularly when I'm in possession of a copy of the relevant police docket, which I hope I will clarify the allegations against me. Your Worship, just to intervene, as is normal, we reserve the right to amplify this affidavit once the state has placed specific facts pertaining to these issues before the Honourable Court. Sub 2, although I have not had adequate opportunity to consult everybody the fact that I may not at this point in time have access to police documents, my intention to plead not guilty to the charges which the state may prefer against me. My intention is premised on the fact that I believe I have a good defence to the charges as I understand them. I have alluded above to the vagueness of the allegations against me. Sub 12, previous convictions. My legal representative has explained the provisions of Section 60 sub 11 capital B of the CPA to me. I respectfully make the exposition. I've never been convicted of any criminal offence and I've got a pending case. There's no warrants of arrest out for me. Then we deal with Section 60 sub 4A, read with 60 sub 5. I do not exactly know who the witnesses is, as I did not want to interfere. If any possible witness, the investigator will be asked to indicate who I may not have contact with. Sub 2, I undertake not to make contact or communicate with any of the persons at the above entities. Your Worship, the entities we refer to is, of course, the limited entities that's provided to us in the charge sheet, as the charge sheet stands. The entities codes we have told me the charge relate to. Your Worship, that is a mistake. It's not the aircraft, so I again ask that that particular section be from relate to. The rest of the paragraph must be deleted. I will make sure that it is Then sub 4, the investigator informed me that he has completed the investigation and the state is ready for trial. Your Worship, we deal with this in the context of what my learned friend has placed before record, that she says it's almost complete. Our understanding is different. So the state may be believed that I need to be placed in possession of statements and evidential material and determined if that's indeed correct. I have a real concern that the state may seek to rely on inadmissible evidence to draw inferences on correct facts when it realized it could do so to force me to commit, Your Worship. I could not do so, would be forced to recommence with the investigation. It's for that reason that I've requested information and I believe given correctly will expose the detriments of the state's case. Your Worship, again, just to place this in context, having regard to this and depending on what the state presents to the court, we might exercise this option, particularly as we entitled to in terms of the provisions of Section 60. Sub 5, ever since the investigation commenced, I've not made any threats or any threats of any nature to any person. The alleged charges may have no relevance to any possible violence. Sub 6, I do not harbour any resentment against any specific person. I have no disposition to violence and have no history of violent conduct. Sub 7, according I submit, there is no likelihood that if I'm released on bail I will endanger the safety of the public or any particular person or that I will commit a Schedule 1 offence. Sub E, I have no reason to flee and not to stand my trial. I've known about the criminal investigation for quite some time. I respect the court and I undertake not to travel outside the country pending the outcome of my trial should I be released on bail. Your Worship, this of course relates to the undertaking that I will not attempt to apply for any travel documents, etc. This is in any event a part and parcel of the conditions already imposed on it. So I undertake not to go to any airport for international travel pending the duration of the trial. Paragraph sub 4, although I accept the charges against me are serious, no intention whatsoever to evade trial, as I need to vindicate myself. My calling as a pastor and my own beliefs are totally inconsistent with crime and the likelihood of evading the trial. Sub 5, the nature and gravity of any punishment which can be imposed on me should I be convicted of the charges brought against me play no part in my actions or decisions, as I believe that I am innocent. I have no intention to bring the criminal justice system, including the bail system, into disrepute. I respectfully submit that the facts set out above support my submission that I do not constitute a flight risk. Sub 7, I'm prepared to submit myself to any necessary bail condition which may be imposed by this Honourable Court. I respectfully submit that there is no likelihood that I, if released on bail, would attempt to evade my trial. Subsection 64C, as stated above, it remains my clear intention not to communicate with any state witnesses. I'm given to understand that the evidentiary material which the state has against me is in possession of the prosecution of the state and the investigating officer, and I presume that it is safely guarded. I'm not aware of the existence of other material which can be concealed, and I most certainly will not conceal or destroy any evidentiary material should I be made aware of same. Sub 3, I respectfully submit there is no likelihood that if I'm released on bail, I will attempt to influence or intimidate witnesses, or that I will conceal or destroy evidence. 16, Sub 4D, as previously stated, I have no previous convictions. I am not on parole. I respectfully submit that there is no likelihood that if I will be unreleased, I will undermine and jeopardize the objectives for the proper functioning of the criminal justice system, including the bail system. It's common cause that I have a pending case. Sub E, I respectfully submit that should I be released on bail, my release will not induce a sense of shock or outrage and will not disturb the public order or undermine the public peace or security. I further submit that my safety will not be jeopardized by my release on bail. 60/9, I respectfully submit that the interests of justice do not require my incarceration. To the contrary, I stand to be prejudiced. The most crucial state of the proceedings of the trial if my application is not successful. 11b, I respectfully submit on the basis of facts set out herein that the interest of justice will be served by my release on bail. General, I will take steps to secure bail in the amount granted by the court. I respectfully submit that the amount should be in accordance with the seriousness of the offence. Sub 2, having regard to my church and country, I have no reason not to stand my trial. I am unable to conduct business as a fugitive of justice. Will stand my trial, particularly having regard to the fact that I am confident that I will be acquitted of all charges should the matter go to trial. I stand to be severely prejudiced by my incarceration. This should be balanced against the fact that I do not pose a risk to the state that I be released on bail. It's then commissioned and signed, Your Worship. I see the date stamp of the police reflect today's date, and it was commissioned by an officer of the court. The list of assets is attached to as A, and the bank account is B. Your Worship, there's just one issue that I need to clarify before I ask that the court accept it as an exhibit. Might I just approach the person? There's one further amendment we want to make, and it's for that reason that I asked. Paragraph 9.9.7, the grade 12, that must be deleted. I realized when I was reading it that that might be a mistake, and I've just confirmed with my client that this entity is no more operative. So 9.9.7 must be deleted. May I then ask the court to uplift the original so we can quickly just initial against the specific paragraph that's necessary. My attorney also just corrected me on one more. It's not 15 bank accounts, it's 12 bank accounts, Your Worship. So we will also correct that issue. Worship, I thus beg leave to hand this up as an exhibit. Everywhere where there's been a typo or a mistake, we've deleted that and the applicant has initials against this. I undertake to make a copy of the same. I will uplift and hand it to my learned friend so we are all on the same page. Your Worship, I then continue
Just
with...
a second, before
Oh yeah, I know your worship has some duties to do. I beg your pardon.
Right, Stage, do you have any objection that you got David here as evidence?
Sorry.
Right, I please to look for that is Sheperd Bushiri. Please stand up. Do you confirm the contents of this affidavit?
Yes, I confirm.
The signature as charged on the third last page above the word deponent is your signature.
Yes, I confirm.
An affidavit in support of the applicant's formal verification, that is accused number 4, who is the first applicant to this application, is accepted as evidence. It is marked as Exhibit I. You can sit down. Yes, sir.
May it please the court to worship, the next affidavit, I hand up the original to the court. That's the affidavit opposed to by Mary Bushiri. Again will try to be Speedy Gonzales with this one. I beg leave to read it into the record, your worship.
Yes, proceed.
I, the undersigned Mary Bushiri, do hereby make oath and state I'm an adult female and accused in this matter. I reside at 972 Victoria Avenue, Waterfall Country Estate, Midrand, where I've been residing since 1 December 2015. And we are tenants at the aforementioned property with our children. 2, I've been informed that I will be formally charged with the alleged transgression of the provisions of POCA, seemingly money laundering, fraud and theft. I have however not had the benefit of being informed what exactly the allegations against me is, i.e. the necessary details one would expect to be confronted with by the South African police when they effect an arrest. I've been informed that I will be provided with the charge sheet of court, therefore reserve my right to supplement the affidavit. In this respect, we have been provided with the charge sheet and will deal with that after the state has presented its case. As stated, I do not have the details of the charges. For that fact, I was informed that it was POCA offences, fraud and theft. 4, I reiterate for the record that my involvement in the charge is not clear as per the communication by the investigating team. My legal representatives inquired from them during the arrest proceedings as to how I'm implicated, to which they responded that I will be provided with the charge. 5, I verily believe that the state has no case against me. I'm not actively involved in the business. I do not know whether the fact that I'm a director in some entities caused my arrest. This would be unfortunate. I am advised the state must have evidence that I participated in the alleged offence, as Section 3325 of the Criminal Procedure Act places an onus on the director to prove non-involvement in the criminal conduct by an entity was found to be unconstitutional. I challenge the state to show how and when I participated in the crime. 6, I deny that any offence was ever committed by me. 7, for this specific reason, I will request information from the state as envisaged in Section 6011B of the Criminal Procedure Act to try and understand what the allegations of the state is in regard to the alleged POCA transgressions for purposes of the bail application. I've already indicated that we'll deal with this issue once the state has presented their case and we still need said information. 8, I accept that Schedule 5 applies to my bail application with regard having to be when regard is had to the financial values mentioned to me during my arrest. I'm advised that in terms of the provisions of 6011B of the CPA, I must satisfy the court that the interest of justice permit my release. 9, my personal circumstances. Sub 1, I'm 39 years old, I'm married and 2 children were born of the marriage, the first on 25 December 2012, the second on 28 September 2015. 9.3, my husband Sheperd Bushiri and I am living with both our children in a normal family setting. At this point in time, whenever we are with our children, we are a family unit. Our children attend school and preschool in Malawi. The fact is well known to Colonel Maritz. In fact, they have arrived in South Africa on 11 October 2020 and they are still here. In fact, they were with me when I was arrested at our family home. Colonel Maritz, together with Mr. Kwashe, our other attorney, are the persons that assist in making arrangements for the children's entry and exit into South Africa. Sub 3, as can see, my children are very young and it's cruel to deprive them of the company of their mother in circumstances where I do not understand the charges against me and why I was arrested in circumstances where my legal team made arrangements to surrender me voluntarily. I fail to appreciate why I would be a flight risk. I have no reason to run away. I have no reason to evade trial as I know I have not committed any offence, let alone an offence for which I should be imprisoned. In fact, as demonstrated by my previous conduct, I that must be changed, for a prolonged period in time. Let me just read it again. In fact, as demonstrated by previous conduct, I now, for a prolonged period of time, adhere to bail conditions imposed to me by the court in the pending matter. Sub 9. Although my husband and I are Malawian citizens of permanent residence in South Africa, and I'm the holder of South Africa.
This is all totaling an amount of 102 million rand. We'll certainly be crossing back there to hear what's happening. We do have our reporters there on the ground as well, finding out what's happening in Pretoria this afternoon. We'll certainly get you more information for you. I do understand that our technical team has been able to get that feedback up for you. Let's cross there.
The allegations leveled against me in particular when I'm placed in possession of a copy of the relevant dockets. Sub 2, although I have not had adequate opportunity to consult with regards to the fact that I may now point to the docket, it is my intention to pick up those charges to the state and prefer it extinguished. My intention is premised on the fact that I believe I have not committed any alleged offence. I have alluded above to the vagueness of the allegations against me, 12 previous convictions in any cases. Your Worship, with reference to 60 sub 11 and A of the CPA, I'm just going to skip directly to the relevant one. Never been convicted in South Africa in a criminal offence up to I have a pending case. And 3, I've been warned that should I willfully conceal or disclose untruthfulness about the two factors that constitute an offence, and if granted, my bail may be cancelled, and that I may be prosecuted, that on conviction I may be sentenced to a fine of exceeding 80,000. Then we deal with the provisions of section 60, sub 4, sub 8, read to section 50. Worship, I respectfully submit that each of these are almost a repeat of what we handed up, where we referred earlier to the prophet, we hereby refer to the prophet test. We deal with section 60, sub 4A to D, and I beg the court's leave not to read same out to save time. Your Worship, I'm indebted to the court. We then deal in paragraph 17 with 64E. That's exactly the same. 1860 sub 9, 1960 sub 11B, and 20 in with the general issues. I then beg leave to hand this up as the next exhibit, Your Worship, and I hand over the chair to Your Worship to confirm the issues with it.
Right. State any objection that this affidavit be accepted as evidence?
Now,
Thank you. The second applicant, Mary, do you confirm the contents of this affidavit? The signature attached on the third last page about the word deponent, is it your signature? Yes. An affidavit in support of the second applicant's formal application, who is accused number 5 in this matter, is accepted as evidence, marked Exhibit J. You can sit down. Yes, defense?
Worship, I then move on to the affidavit of Landiwe Ntofwani. Your Worship, it says, I the undersigned, oh, sorry, Your Worship, I beg first, I beg leave to hand it up. Affidavit bail application. I, the undersigned Landiwe in Tlokwane, do hereby make oath and state as follows. I am an adult, 37-year-old female, self-employed, independent financial consultant with ID number 830926057486, who reside at number 78 Craigavon Park, Elm Street, Craigavon, 4 West Gauteng. I'm the applicant in this matter. Unless otherwise stated or appears to the contents hereof, the facts contained herein are all within the scope of my personal knowledge and are to the best of my knowledge and belief true and correct. Where I made submissions of the legal nature, these are made on the advice of my legal representatives, with advice I accept as correct. 4. I've been advised that the state alleged that the matter results under Schedule 5 of the Criminal Procedure Act, Sub 5, and 5. I've been advised that in the respect of a matter that results under Schedule 5, the CPA specifically state that an accused having been given a reasonable opportunity to do so, it relates to Section 6011. 6. I've been advised that having regard to what is stated above and based on the facts dealt with herein under, that I have not been given a reasonable opportunity to adduce relevant and pertinent evidence as to discharge the onus I bear when dealing with the Schedule 5 offence. Full legal argument in this regard will be made at the hearing of this matter. In amplification of my application to be released on bail by the Honourable Court, I've been advised to place the facts set out herein before the Honourable Court for due consideration. I've also been advised regarding to relevant and important legal submissions, which I will deal with in this affidavit. Then we deal with the structure of the affidavit. I then start with the personal information. I'm a South African citizen with ID number 830926057586. My date of birth is 26 September 1983. I'm 37 years old. My place of birth is Soweto, Johannesburg. I attend
We are outside the Pretoria Magistrate's Court, where the supporters have gathered in their numbers. They are still in high spirits since very early this morning, awaiting the court outcome. And you're quite correct. The proceedings are finally underway inside. Of course, you remember, first we had the media application trying to seek permission to be able to record live proceedings. Now that matter was granted by the court. So now the second stage of this appearance here is that the Bushiris are now finally taken the stand and they've applied for bail. You remember they were arrested on Tuesday and they appeared on Wednesday in court. The matter was then postponed to today. And currently inside the court, what's happening is that what's happening right now is that currently in court the two have now appeared and they are applying for that bail. The supporters, it's quite noisy outside. The supporters are out here in their numbers, and what they've told me is that they are not going to leave here until their pastor, Sheperd Bushiri, and his wife are released. So there's a bit of a mini service that's taking place outside. Lots of singing with songs to try and keep themselves going as they as they await the outcome of the court proceedings. And I think right now we can go back to court and follow those proceedings inside as the Bushiris apply for bail.
It was here that I conceived the idea to register a company in order to provide independent financial advice and with a long-term vision of providing financial literacy on a large scale. Next paragraph, in 2015, I indeed did register a company. In terms of the provisions of the Company Act, the company's name is Genesis 12 Wealth. GTT Wealth was registered as a financial literacy training company with the aim of providing independent financial advice in the future. 27, during the period between registration of GTT and December 2016, I was mostly involved in speaking engagement, which I was compensated for with honorarium. GTT was a startup company, and for that reason my time was mostly spent on writing proposals making necessary business connections, and attending network events, amongst others. During this time, I did not earn a stable income from GTT. In fact, in order to sustain my daily living expenses and the daily operational expenses of GTT, I relied heavily on angel investors. 39, during the period of about the beginning of 27 up until around December of 2018, I fell into a deep depression because of the stress associated with startup business. I spent almost all my time volunteering at the Enlightened Christian Gathering Church and other charities associated with other ministries. 30. As an entrepreneur, it's important for me to support other fellow entrepreneurs. During the period that I was employed by Allen Gray and Cloud Investments, I invested various amounts of money into small businesses and stockvels. These small businesses and stockvels periodically repaid the loans and gratuities as and when my need arose during the period of 2018 to date, which is how I'm currently surviving and rebuilding. Paragraph 31, I further received payments on various other loans I've given over the past number of years, although my years as an employee to certain individuals of my family and the community. 32, I often organize and arrange events for the Enlightened Christian Gathering Church, which the church compensates me with gratuities. I also attend seminars where I engage in public and motivational speaking. These engagements are also compensated with gratuities. These gratuities is how I sustain my livelihood. 33, I also teach free financial education every Friday via an online application, Zoom, called Financial Fridays. As part of my ongoing career and skills development, I'm currently pursuing a bridging course in accounting through Mill Park Business School. 34, I occupy the property at number 78 Carnarvon, Elm Street, Carnarvon, Four Ways, Gauteng, with my biological mother. The property is leased to us for a monthly repayment of 8,320,000 rand. A copy of the lease agreement is made available to the court if same is requested. I just want to make sure, Your Worship, whether it's attached. It is not. We will just make sure that it's handed up to Your Worship. It was handed up previously. I occupy the property, I continue 35. I'm the person responsible for the day-to-day needs of my household, which include rental, groceries, water and lights, maintenance and upkeep. I've resided at the aforementioned residence since December 2018 with my husband. My mother moved in with us in 2019. I previously resided at Talavarra Estate, Inyanga Road, Carnarvon, in Four Ways. Your Worship, just to again place the court into, or places into context, her husband permanently resides in Cape Town, and when he's up here, he stays with her. Then we deal with the marital status. I'm married to my husband, whose detail I wish to withhold to protect his privacy. I will make a document available to the court in which I will disclose these details at the court's request. We have been living together as man and wife since 2013. Next one, my husband is employed by asset management manager, Cape Town. I travel between Johannesburg, Cape Town every fortnight to spend time with him. My mother is a 65-year-old pensioner who is financially dependent on me. I withhold the details to protect her privacy. I will make a document available to the court in which I will disclose these details at the court's request. As stated above, she currently resides with me. 40. My first younger sister lives in Midrand. I have one niece and one nephew through her. I will hold their personal detail to protect the privacy. I will also make a document available to the court in which I disclose these details at the court's request. 41. My second younger sister lives in Pretoria. I will hold her personal details to protect her privacy. I will make a document available to the court in which I disclose the details at the court's request. Your Worship will notice from the document that we handed up in the emails, all these details are contained therein. And I think the important fact is that we've made it available to the investigating team to follow up. 42, I do not have any children. However, my mother and my sisters are financially dependent on me. My sister's children are currently homeschooled for financial reasons at my residence in Carnarvon Park by myself and my mother. 43, I have two paternal half-sisters, one paternal half-brother and a stepmother living in Ndola, Zambia. The last time, many years ago, I wish to emphatically state that I do not have a close relationship with my half-brother and half-sisters. Assets, I own both immovable and movable property. My movable property is valued at 20,000 and it includes clothing items and other personal items. My immovable properties are as follow. We then state that 10 Whitlock Street, Central, Port Elizabeth, valued at $2,200,000. The property is bonded. As I say, we are in possession of the lease agreements. They were also made available to the investigating team on the joint owner of a property which is situated at number 2 Markham Court, Lansdowne Road, Cape Town, valued at approximately 2.3 million. The property is with Standard Bank. There is, however, substantial equity in it. Expenses: I'm responsible for making payments on behalf of myself, my mother and my younger sister in respect of inter alia loans, rent, household expenses, cell phone and expenses, and other travel expenses. My expenses pertaining to the well-being of my mother and my sisters often surpass an amount of 10,000 rand. Without my financial support, my mother will not be able to survive the charges. At the time of writing this statement, neither myself nor my lawyers have been afforded the benefit of consulting with one another, either on the charge or the context of the police docket. Myself and my legal team has also not been afforded an opportunity to consult on the warrants of arrest which have been issued, nor the underlying affidavit thereto. I understand, though, through discussions between myself, my attorneys, Advocate van der Heeven, and the rest of the Directorate of the DPCR, I'm just going to shorten it, Worship, that the charges preferred against me may fall under Schedule 5. Paragraph: I reserve my right to reply to any allegations made by the state in these proceedings as and when I receive any information pertaining to the matter at hand. Paragraph 51, I've been advised of my right in terms of Section 35 of the Constitution, and more specifically, I have a right to remain silent with regard to the merits of the matter for purpose of my application to be released on bail. I hereby exercise such right. That is, of course, depending on what the state says, and we then reserve the right to amplify. I wish to state emphatically that I'm not guilty of any wrongdoing at the time. Wrongdoing. Worship, that section, the last 3 words must be taken out. We will again deal with it on your Worship's original statement. As stated above, I challenge the state to set out in details of what I've alleged to have done, thus affording me the opportunity to consider and meaningfully deal with these said allegations. Travel documents: I hold a valid South African passport, no reservation handing over my passport to the court and or the investigating officer. History of antisocial behavior: previous convictions. I have no previous convictions, no pending cases. Submissions regarding the factors to be considered when deciding bail should be granted. Your Worship, then we deal with Section 64A, danger to the public, 64B, C, D, and E. Again, I beg leave to the court. These are the regular submissions that's made, not to read same into the court, and that we later on argue that. I then also deal with Section 60 sub 9, Your Worship. Again, these are commonplace submissions made in an affidavit, and it's normally fully addressed when the submissions are made to the Honourable Court. Your Worship, I think what is important, though, is I want to very quickly deal with 62. I submit my incarceration awaiting trial will prejudice me in the extreme, in that I'm likely to stay in custody for a lengthy time in view of the fact that the investigation in this matter is likely to continue for many months. This is, of course, premised on what we heard on Wednesday from the prosecutor. I've been advised, which advice I accept, that it will take a period of approximately over a year, if not longer, for the matter to be set down for trial. Your Worship, this we, of course, premise on the issue of the trial roads. It's common knowledge that COVID-19 has severely affected trial roads. 64, I undertake to attend at court on every postponement hearing pending further investigation for the trial of this matter and the trial that may ensue. 65, I submit that if I remain incarcerated, I will undoubtedly suffer serious financial loss of the fact that I will not be able to attend to my business, family responsibilities and social commitments. My financial loss, should I continue to be incarcerated, will be irreparable and will have far-reaching adverse consequences on me and my family. 66, I further submit that my incarceration continues to detention pending trial will not in my best nor in the best interest of justice. Paragraph, I will also be separated from my husband, my mother and my sister, with whom I love dearly, with good cause. It is then commissioned, Your Worship, and signed by the applicant. Before I hand it up, may I please request that I uplift Your Worship? So, do you know which paragraphs we want to change? In the meantime, I'm going to hand up the lease agreement that's as Annex A there to Your Worship. Your Worship, I beg leave to approach the... Where's my pen? Come. Your Worship, I then beg leave to hand same back to Your Worship. There is the lease agreement, that's Annexure A, Your Worship. Here it is. Your Worship, reference is made inter alia to the lease of the first and the second applicant's property. We didn't think it's necessary to hand it up, but we will, just for completeness sake, do so in due course. The state is, as far as my recollection, by state I mean the state and the police, are in possession of same. Your Worship, the issue of the title deeds, that is also already in possession of the state and the police. If necessary, we will make sure that those are handed up to the Honourable Court. I'm happy to do that, Your Worship.
No objection, Your Worship.
Thank you. Ma'am, do you confirm the contents of this affidavit? The signature that is attached on the second last page above the word deponent, is it your signature? Yes. An affidavit in support of the third applicant's formal verification, who is accused number 6, is accepted as evidence. It is marked Exhibit K.
May it please the Court, Your Worship, Your Worship, I then respectfully submit this is provisionally our case. We do, however, reserve the right to supplement this case if and when we have sight of the affidavits produced by the state, with reservation also of the issues that I have dealt with before with Your Worship. I have nothing further at this point to add, Your Worship. I do, however, want to state one thing for the record. Unfortunately, yesterday there were issues to get access to the accused at prison. We attended there and we waited for more than an hour. I know the head of the prison quite well. He was even approached, and we were just told that it's impossible to get access because of various COVID-19 regulations. So I just want the court to be aware of that we were deprived of an opportunity to consult with our clients. This morning, we had the same issue. Our time with our clients were very limited in that they arrived very late at court, and there was various issues that we needed to deal with that took preference this morning, one of them being the application for media release. Worship, if you will bear with me, I'll just... we have nothing further at this point in time, Your Worship.
Thank you. Right, it is now 10 minutes before 4 o'clock. Obviously, this is going to become a public matter. We need to arrange a date when we can proceed with the case for the state, seeing that the applicant's case is closed. Right, advocate, what is happening? There's accused number 1, number 2, as well as the company cited as accused number 3. They are appearing in this court on the 30th of October. We arranged this date as preference, and on that date, there aren't any formal verifications that are opposed as such. There's only 2 stopper matters, but those 2 matters are going to take more or less 10 minutes for each. It's not going to be long. So I suggest that we proceed on the 30th of October. The reason why I'm saying that is because from Monday, there's a matter that was booked for the entire day. State, this is, can't mention his name, but it's booked for the entire day. There's 2 accused persons in that matter as well. There's another matter as well that is booked for that day. For the whole week, there are matters that were pre-booked, and the people have been in custody for a lengthy period. Because of COVID-19, there was a time when we couldn't proceed with the formal verifications, at times when the building is closed down because of COVID cases. And those people have been placed on the road and given preference, seeing that they've been in custody for quite some time. The 30th is reserved specifically for this matter, that is for accused number 1, 2, and 3. I don't see the reason why we cannot proceed on that day and hopefully finalize this formal verification.
Your Worship, may I just place the following on record? I have learned that there was an urgent application yesterday in the High Court pertaining to the matter that Your Worship has just referred to, and there was an agreement reached by the state and the defence that that matter will appear in court on Monday. May I ask for a 5-minute adjournment? I need to take instructions on your worship's suggestion. I believe that will not find favour with my client, so I need to take instructions if it pleases the court. Thank you. Yeah, we will phone you, your worship. Thank you very much for the indulgence.
There saying that she needs to get instruction from her client. We heard there the magistrate dealing with some admin issues, that some of these issues were supposed to have been dealt with earlier on, but of course due to COVID-19 a lot of things had to be postponed. We'll certainly get you back in court certainly after that adjournment and get you more details there. Let's also just take a short break for now. More news after this.
Everything is fine. We can pick it up.
We've stopped the cables.
Yes, you stopped the cable.
They're coming back. Yeah, I think they're coming back. Yeah.
I'm facing so many challenges.
So I change it. Okay, okay, Mina. Okay, it's him guy. It's him guy phone. Kulmena. It's him Kulmena. Guy phone. Yes, sir. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Is it fine? Oh, I think the problem is the camera. Because even earlier in the crossing, we had a sound problem.
Okay, let's see this. Let's try this.
from her client. Did you get a grasp of what exactly that clarity that she was seeking was and what's currently happening there in the courtroom?
Good afternoon, Flo. Well, it's been a very long day, as we have probably seen earlier. A large number of people from the ECG Church, gathering outside in support of their leaders, who were arrested on Tuesday, following the Hawks' request, to have them meet with them at their offices in Silverton to discuss issues relating to an investment company called Rising Estate. So this morning, there was a bit of a delay because the media initially was not allowed to film inside. And it was only after lunch when an order was actually granted for the media to go ahead, but only granted to one media house, obviously. And some of the arguments that the defense put forward in court was that in the previous cases, their clients have never been shown anywhere.
Molema, are you still with us there?
In their interest.
All right, Molema, I think we're struggling a little bit with the line there, but if you can still hear me, let's talk about some of those admin issues that I heard the Magistrate Tandita lady talking about earlier on. There was talk about COVID-19 having delayed some other things as well. Just give us some clarity on what the Magistrate was actually talking about at that time. All right, we seem to have lost her there, but certainly there is a lot going on there in Pretoria, inside and outside the court. We're going to try and get hold of Molemo just to give us more of an update. Certainly there was a bit of a break there in our communication, but what we are really talking about at this time is the fact that the legal counsel, speaking on behalf of Bushiri, spoke about the fact that he is indeed challenging the state to prove his involvement. There are a couple of charges that he and his wife face, and of course another couple. They're facing charges of money laundering, they're facing charges of fraud, the contravention of Organized Crime Act, and all of that totaling about 102 million rand. And they've said that they asked the state to prove that it was illegal, in any way illegal. But certainly those who arrested them seem to have some kind of information. So we'll give you more information coming from the Pretoria Magistrates Court, and we'll go back in after that adjournment. They say 5 minutes, but it's usually a little bit longer than that. As soon as we've got that feedback up from the courtroom, we'll certainly get you back in there. All right, let's move on to other news while we
16/679 of 2020. It was put down earlier on for arrangement of date.
With
May-
the court's permission, I'm sorry, for counsel, may I just have an opportunity just to place the court in picture? There was an urgent application in the High Court for accused 1 and 2, which was heard yesterday, and it was struck from the roll as it was not urgent. The state, however, with counsel for accused 1 and 2, new counsel, not the counsel that's currently on record, committed to obtaining requisitions for them to come to be brought to court on Monday, which would place them within the 7-day postponement days. So they will, it was delivered and confirmed that the prison will bring them to court on Monday. It was all over, stated to counsel and mentioned to the judges, the Honourable Puri, that the court roll is of such a nature that it might not be conducive in proceeding with the bail application. So those parties are well aware of the situation.
Your Worship, may I please the court, and I want to start off by stating the following. It's no disrespect to this honourable court. As counsel, we are creatures of instructions, and on that basis I wish to make the following submissions to your Worship. First of all, bail is always urgent. As Mr. Justice Cameron has said in the matter that I quote to you, accused people should not be placed at a disadvantage because of institutional delays. My instructions from my attorney and my clients are that we wish the matter to proceed on Monday. Your Worship quite correctly earlier stated this bail is urgent and it must be dealt with urgently. We understand the practical problems that there might be, but your Worship knows as well as we do, and the state knows, that very often matters fall through. They don't proceed for whatever reason. Either there's a change in attitude by the parties, etc., etc. And it's for that reason, your Worship, we're going to ask the court that the case be postponed till Monday. The other accused are also here on Monday. My learned friend just confirmed it. We are fully willing, your Worship, to sit and await our turn. For this matter to be postponed till Friday, your Worship, with the greatest of respect, the state then achieved exactly what they set out to achieve. And that is not fair. Your Worship has made your ruling. You ruled against them on this Section 50 sub 6 application. Your Worship, quite correctly, and we fully concur with your Worship insofar as we are allowed to concur with a presiding officer state, that they've got more than ample opportunity over the weekend to deal with this bail application. It happens every single day in our courts that counsel and state prosecutors work over the weekend, so do police. Your Worship, we respectfully request this court that based on numerous case law, on the provisions of the Constitution, that the liberty of an accused is always an urgent matter. That your Worship makes a ruling that the matter return on Monday. We will wait our turn on Monday and deal with the matter then as it comes. More so, as I say, because the other accused will also be in court, and I think it will be quite important to hear argument by everybody on that occasion. I might just approach my attorney, your Worship. If you will bear with me. That is my submission, your Worship.
As long as we all agree that you will fall in line.
Indeed,
because there are other people who are appearing whose bail applications are preferred.
Yes, your Worship, we are happy with that arrangement. As I stated to your Worship, we will await our turn for Monday. May it please the court.
There's also a possibility that we might not be able to get to it. We understand that, but we are willing to take the chance in that regard.
Your Worship, that would in any event also give us an opportunity, based on your Worship's ruling, that the state must utilize the weekend to be prepared to see what they say, and in any event have their affidavits and prepare any supplementaries that's necessary. May it please the court.
I am, your Worship.
Please stand up. Thank you. We are possibly, if the NPAS is on your way, possibly going to continue with your formal verification this coming Monday, the 26th of October 2020. As I've mentioned to your legal representatives, there are other matters on the court road that take preference. Depending on whether those matters are going to proceed or not, you will have to wait your turn on Monday. We'll all be in custody until Monday, the 26th of October 2020. You understand? Mr. Young?
Please be quiet.
Bishop, may I be excused just to go and speak to the clients? Thank you. Will you watch my video?
Your Worship, I confirm that is the role.
Correct.
All right. Thank you.
All right, we'll take you back to that court, but we certainly did get an idea of what that instruction that the advocate was seeking was, that we were asking Mulema about. She said that she was instructed to ask the court in the matter to proceed, as this is an urgent case and must be dealt with urgently. And in relation to the bail application then of Bushiri and his wife Mary, she asked that respectfully, asking the court that liberty of the accused is indeed an urgent matter and that they be let free this for this weekend. So we'll get you more information on that throughout the bulletin. We are sticking to that. We have Sipho Stierman outside the court and Mulemo Waone Mutwa inside the court. So very well represented SABC News this afternoon for you. You won't miss a thing from there. We'll keep you updated. Let's move on to other news then. Salga has instructed local
Are you okay?